It's a medical malpractice trial. My expert is on the witness stand. I just finished questioning him. The defense gets an opportunity to cross-examine him, and one of the first questions he asks is, "Hey, Dr. Jones, did you have a conversation with Attorney Oginski before you got on the witness stand?" And just as I'm about ready to jump up and object, I have a second thought, and then I sit back down and I allow him to proceed unobstructed. You want to know why I do that? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. Now, this scenario is a little bit different when my client is on the witness stand, and now the defense attorney questions my client on cross-examination and says, "Hey, Mr. Jones, what did you and Attorney Oginski talk about before you got on the witness stand?" Well, any conversations that occur between the attorney and client are private, they're confidential, they're privileged, which means that the defense attorney can ask all he wants, but he's not going to get any information about what it was that we discussed. Now, contrast that with the scenario I just described, where my medical expert is up on the witness stand. It's now time for him to be cross-examined, and now the defense lawyer asks him, "Hey, Dr. Jones, what did you and Attorney Oginski talk about before you got on the stand?" in a very accusing tone. Now, I could jump up and object, but you know what will happen? The judge is going to turn around and say, "Objection overruled," which means the question is proper, and Dr. Jones, you go ahead and answer that question. So the conversation that occurs between the attorney and the medical expert is discoverable, and the doctor will then have to answer questions. But you will find that really smart defense attorneys are not going to delve too much in detail about the conversations that occurred between the attorney and the expert. You want to know why? It's because you never ask a question to which you don't know the answer to. If you do, the answers are always going to come back and bite you on the butt. That's why they'll touch upon certain things and certain conversations without going into explicit detail, because they don't truly know what the conversation entailed. And more likely than not, anything that the doctor is now going to say is going to bite the defense attorney in the butt, and it's going to harm his particular claims. So why do I share this great information with you? I share it with you just to give you an insight and an understanding to some of the strategies that occur during the course of a medical malpractice trial here in New York. You know, I recognize you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're contemplating bringing a lawsuit and you've got legal questions, what I encourage you to do is pick up the phone and call me. I answer questions just like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207. or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.